The Supreme Court has rejected the final appeal from Pennsylvania Republicans against the result of the 2020 election. But the court left a critical question unanswered. NBC News Justice correspondent Pete Williams explains.
This was the last of the court fights over Pennsylvania's general election to reach the Supreme Court, and now it, too, has been dismissed as basically a dead letter. That's no surprise, but it does leave a question unanswered that's not going to go away. This was an appeal from Pennsylvania Republicans who said the Secretary of State had no authority to extend the deadline for receiving mail ballots in the 2020 general election. This was a lawsuit filed by Jim Bognet, a Republican candidate who lost the general election for one of Pennsylvania's seats in Congress, and 4 other Republican voters. They challenged the Secretary of State's decision to allow 3 extra days for receiving mail ballots from Tuesday evening to Friday evening. The state said it needed all that extra time, given statements from the Postal Service that delivery would likely be slow. The Republicans said only the state legislature could authorize such a change, but that claim was rejected by Pennsylvania's own Supreme Court, and then the U.S. Court of Appeals for the Third Circuit left that ruling undisturbed. Pennsylvania officials urged the Supreme Court not to take this case, declaring it as moot can be, given that the election is long since over. And besides, the state said the total number of ballots at issue, which was about 10,000, was less than the margin of victory in each of the state's federal races. In other words, even if the challengers had prevailed in their legal challenge, it would not have affected the outcome. Republicans have brought similar challenges to voting changes in other states, all based on this claim that only legislatures can make substantive changes in voting procedures. The U.S. Supreme Court has never actually ruled on whether that is, in fact, how the law is supposed to work. Even so, 4 U.S. Supreme Court justices and some lower court judges have said from time to time that because the Constitution provides that every state must choose its presidential electors, quote, in such manner as the legislature thereof may direct, then only legislatures can alter the voting rules. But in the 2000 Bush v. Gore case, that notion attracted the votes of only 3 justices, so it was not a holding of the court. And then in a 2015 case, the Supreme Court said the Constitution's reference to the word legislature in a separate, similar clause of the Constitution meant the entire lawmaking apparatus, not just the 2 state houses. So that issue remains unresolved and will undoubtedly come back in some future election challenge. Savannah, Joe?
Thank you, Pete.
Hey, NBC News viewers, thanks for checking out our YouTube channel. Subscribe by clicking on that button down here and click on any of the videos over here to watch the latest interviews, show highlights, and digital exclusives. Thanks for watching.